Well, thank you all for joining me for this presentation. There's about, how many of us in this room? About 9 of us in this room, and I don't know how many of you are around Australia, but welcome all. And what I'm going to talk to you today about is a relatively new concept in Australia called witness familiarisation. And you'll see the title of this presentation is Walking a Fine Ethical Line. The good news with the use of the E word there means that for those of you scrambling around for your ethics point, as we come to the end of the CPD year, this counts as your ethics point. So thanks for coming along. This is a little bit about me. I do actually do some legal work despite the introduction that Scott gave me. I'm a barrister in McPherson Chambers, specialise mainly in commercial law, have done more trials than I can remember and have cross-examined more people than I can remember. But what we're doing here is talking about Loquitur, which is Australia's leading witness familiarisation and training organisation. And we'll talk about what witness familiarisation is, whether it's ethical, how to do it, how you can cross ethical lines, how you can protect yourself when engaging in it. So let's start with the scenario. You've been working hard on a misleading or deceptive conduct case. You're for the plaintiff. There are 2 defendants, a company and an individual called Barry. The company, like most companies, is worth nothing. The individual, Barry, though, owns 4 unencumbered properties with ocean views, and he's sitting on a mountain of cash because he just sold his GameStop shares before the bubble burst. Your client's case is based on an oral representation, and your client needs to give direct oral evidence that Barry made the representation directly to him. It was Barry, no one else, and your client remembers it as clear as crystal. But your client is new in court. He's intimidated by the process. He starts being cross-examined and he goes to water. Oh, I can't remember. Well, maybe it wasn't Barry. Oh, there are a lot of people there. Look, can I speak honestly? I can't remember who said what to whom. Sorry. Your client's just harpooned his case, and all your hard work and all your late nights, you're scratching around through his business records trying to prove his damages. It's all been wasted. What if there was something you could do about that before it happens? What can be done? Is it ethical? Let's find out. Here's a quick overview of what we'll be talking about. Some definitions, the differences between witness proofing, witness preparation, witness training, witness coaching. We'll look at what the practice rules have to say about all of these things. We'll look at some hypotheticals, and this is where we find out how ethical all of you really are. Based on real case law from around Australia, the UK and Hong Kong. Then we'll have a bit of a talk about this relatively emergent process in Australia of witness familiarisation. And then Claire Denham, the graduate, you graduate, Claire? Solicitor, has volunteered / been forced to subject herself to a mock cross-examination. So let's have a look at what this means. The fine line. When does ethical preparation become unethical coaching? There's this quote here. This is a fine line between legitimate witness preparation and unethical coaching of a witness. Despite the difficulty of drawing that line, the courts insist upon its maintenance. Whether or not preparation amounts to unethical coaching is, as with most things in law, necessarily a fact-specific and involves matters of degree. That quote, as you can see, comes from a paper delivered by His Honour Justice John Griffiths back in 2014. You can, if you want to, look at this paper on the Federal Court website. It doesn't just deal with witness familiarisation, but it deals with the issue in some great depth. It's worth a read, actually. Now, witness proofing, what's that? Something that we all should be doing, but in my experience, particularly with litigation in the state courts in Queensland, is becoming increasingly rare. It's obtaining a written summary of what the witness will say in their testimony. It should be done separately for different witnesses. We'll have a talk later on about why that is important. It should be kept as a record. It will often form the basis of a statement if necessary, and it is best practice. Now, why do I say it's best practice? What do you think in the room for lawyers? It provides a written record of what your client is going to say. The number of times I've seen clients go off-piste in their cross-examination and have told stories completely different to what they've told me in my chambers and their solicitors. It's to protect you as much as the client. Clients always push back on it because the preparation of witness statements is expensive. It's probably the second most expensive thing after disclosure. But it is hugely important to protect you as the solicitor. And I can tell you as a barrister, if you get a brief with statements of evidence in it and they're signed, it makes trial preparation so much easier. It makes it so much faster, so it is actually a cost saving for clients. And no less than His Honour Justice of Appeals Scheller has said, it has long been regarded as proper practice for legal practitioners to take proofs of evidence from lay witnesses. But, as His Honour emphasised, it must be done separately. Now, this is obviously not such a problem where, in particularly the federal jurisdiction and tribunals, most evidence in chief is given by way of affidavit. However, state courts, it's still important. Let's have a look at witness preparation. What's that? It's a general discussion of the witness's evidence with the legal team in the lead up to trial. Obviously, you should be doing this. It can include proofing and types of ethical training, and it can and should include questioning and testing in conference of the evidence to be given to a prospective witness, and drawing the witness's attention to inconsistencies or other difficulties with their evidence. That is really important. Human psychology is such that humans remember things in a way that protects their own ego. Clients don't like, get rid of that. Clients don't like dealing or even answering questions that are potentially painful to them, that make them look bad. You need to press where it hurts before your client gets into the courtroom, because you can bet that the other side's barrister will. And as I think anybody here would know, you don't do your client any favour by just drinking their Kool-Aid. Witness training, what's this? We're getting a bit closer to that ethical line with this. It's difficult to define. It's often used as a general term for witness preparation or witness familiarisation, and even witness coaching, so you can see we're getting fairly close. It can include teaching a witness techniques and strategies to give evidence and deal with cross-examination. It's not unethical per se, it depends how it's done. There's a quote there from the wonderfully named Lord Justice Judge from the UK in The Crown Against Momadou. The final sentence is the one that I like. The critical feature of training of this kind is that it should not be arranged in the context of law related to any forthcoming trial and can have no impact on it whatsoever. Now, witness coaching. We've all heard about this, haven't we? If not, you should have. It is unethical and it is prohibited. But what is it? It is a rehearsal of a witness's evidence to get them to give responses that wouldn't be completely natural. And the quote from the Crown Against Salisbury, another UK case, is it's about the orchestration of the evidence to be given. So as opposed to telling someone how to play a particular melody, it's telling them what the melody should be. Coaching will occur where the witness's true recollection of events is supplanted. This can occur either through the lawyers suggesting to the witness that this is what they should say in particular circumstances, or it can be something as simple as getting the witness to read their statement over and over and over again until the evidence they give is, it's not really genuine, it's just a regurgitation of the statement itself. Now, one thing I want to address here is, how do we avoid coaching when we're preparing affidavits? We all are involved in the preparation of witness affidavits. Some of you may have seen, a bit of a humble brag here, my previous CPD for the Law Society on expert evidence, and to what extent lawyers can be involved in giving expert evidence. The courts have said over many, many years at all levels that lawyers should be involved in drafting expert reports. I can't see any logical reason why lawyers shouldn't be involved in drafting affidavits for lay witnesses as well. And of course, the problem is you can't tell your clients what to say in their affidavits, but you can tell them how to say it. Just a quick poll here. I'm sure the rest of Australia can't see you, so put your hands up. How many of you have asked your clients to email you their version of events, and you've got 3 pages of unpaginated, rambling text that just covers all sorts of things across a range of topics at various points? Hands up. 1, 2, 3, 4. Right. It's your job as a lawyer to assist your client and the court to whip that into a shape that is palatable to somebody who has no idea about the facts, i.e. a judge, but obviously you can't supplant anything in there with what you think the client should say. Let's have a look at the Australian Solicitors' Conduct Rules. They effectively reflect the common law. So this applies to solicitors. You can't suggest that a witness should give false or misleading evidence, obviously, or condone that they do so. You can't coach a witness. But you can, of course, and indeed should, give your clients a general admonition to tell the truth. You could just say tell your clients to tell the truth. That's probably clearer, but anyway. Questioning and testing in conference the evidence of a witness or a prospective witness and drawing their attention to inconsistencies or other difficulties with their evidence. Really, as I said, these rules follow the common law. Barristers' rules, it's effectively the same. Again, we go a bit further here. The barrister must not confer or condone with another practitioner or more than one lay witness or a party at the same time. Does anybody know why that is? Any suggestions? Well, people tend to just agree with other people in the room. If you confer with the boss and a whole bunch of other employees at the same time, the employees are sure as day that are just going to agree with whatever the boss says. Witnesses have to give their own evidence in the way that they recall it, and I can tell you judges are very suspicious of witnesses for a particular party if all the witnesses line up exactly and say exactly the same thing. And even in the preparation of affidavits, I think there was a decision of Judge Jarrett, who's on the Federal Circuit Court up here, and all the witnesses had to give effectively evidence about the same thing, and all their affidavits said exactly the same thing. The names were different, and I'm fairly certain His Honour refused to accept the affidavits because he considered that it wasn't the witnesses' own evidence, it was the witnesses of the lawyers. The witnesses just signed it. So you can't confer with people, or you can confer with people but do it separately, and the rules are effectively the same in Victoria, and for those of you interested, they're reflected in the UK as well. These principles are common, as we shall see, throughout the common law world. What are the consequences of the failure to comply with your ethical obligations? Well, most immediately, as it says there, the witness loses credibility and subsequent effect on the case and the client, whereas the judges say, I afford the witness's evidence little weight. But for you, possible disciplinary action, we'll see a case where that happened, possible contempt of court, and I even found a case from the 80s in America where a solicitor, or well, a lawyer over there, conferred with clients altogether and rehearsed them with their evidence. The court found out about it, decided the solicitor was in contempt of court, and he went to jail. Now, I haven't heard of anything like that happening in Australia, but it's not beyond the bounds of reason that it could happen. So don't do it for your client's case, but more importantly, don't do it for yourself. Now, whether preparation amounts to coaching is inevitably a matter of degree and is dependent on the facts. This is from that Majinsky case I referred to earlier. Bearing that quote in mind, let's have a look at some hypothetical scenarios, and I'll ask you all whether you think the ethical line was crossed in these scenarios. Hypothetical 1. So you're, for the defendant's lawyers, the defendant runs a ski resort. The defendants are being sued by a fellow. He was operating the ski lift at the bottom of the mountain, and he got crashed into by a wayward skier and allegedly injured his leg quite badly. So you decide it's a good idea to send a letter, an extensive letter, to one of the witnesses, whose name is Ken. And the letter sets out the questions that Ken and other witnesses in the case may be asked and the types of things they should say in response. The letter tells Ken and the other witnesses to satisfy themselves not whether X is the case, but that X is the case. In particular, things like number of guests at the ski resort that day, what the signage looked like, the general distance to the stop button for the lift, because we want to say that it wasn't too far away. The general conditions at the ski lift that day, other things like that. And then the letter also tells Ken to tell another witness, Daryl, to familiarise himself with things that he might not actually have any knowledge about so that they can lead evidence from Daryl about those things too. And it says, if you could pass this on to all the other people mentioned in the letter, that would be great. What do you think? Hot or not? Hands up who say hot. Hands up who say not. Good. You're right. Not. That's what the Court of Appeal said in Day and Perisher Blue. A new trial was ordered and the defendant's solicitors were asked to show causes to why the matter shouldn't be referred to the Legal Services Commissioner. The court, if you read the judgment, didn't actually go into too much detail to explain why the solicitor's conduct was worthy of referral, because I think the judge who wrote the main judgment just decided, look, this is so obvious, I don't even need to say it. And the matter was subsequently referred to the Commissioner. I don't know what the outcome was. We've done some looking at Loquitur into this. Does anybody know? Does anybody want to know the name of the firm? It's published in the judgment. Well, the firm that was representing the defendant at the appeal, or the respondent because the plaintiff lost, was the now defunct Gibbs Barker. I don't know whether there's a connection between the two. Anyway, pretty bad, pretty bad. Right, let's have a look at another one. This is a criminal case. Probably not within everybody's wheelhouse here, but still comes up, and it's because it's to do with vulnerable witnesses. It's possible that we're all going to deal with a vulnerable witness, somebody with a head injury or some sort of intellectual disability in our career. So a criminal case regarding sexual offences against a child. The complainant child had met with the prosecutor. Now, bear in mind that in child evidence cases, their evidence is normally pre-recorded. So the child's evidence had already been recorded. The child met with the prosecutor again, and during a wide-ranging and comprehensive discussion, the prosecutor showed the child the video of his previous evidence and invited the complainant to comment on that evidence. The prosecutor asked the child questions about his evidence, and he also showed the complainant a photo of the accused and asked him to identify him. What do you think? Hot or not? Who says it's okay? Two people up the back there. Who says it's not okay? Oh, there's a few grimaces here. Well, let's find out. In this case of Majinski, showing the complainant the video of his previous evidence and speaking about what it was did not cross the bounds of propriety. All the prosecutor did was just ask the complainant about their evidence, and it was only 2 instances, so there wasn't really anything to indicate that the child was being rehearsed in their evidence. However, showing a photograph of the defendant when the issue of the defendant's identity was likely to be an issue was inappropriate, the court said. However, it didn't affect the outcome of the case because, luckily for the prosecutor themselves, the child stuck to their original evidence about the identity of the perpetrator, or of the accused rather. So showing the photograph didn't really have any effect on the outcome. So the boundary of impropriety is only crossed if the course taken by the prosecutor has the effect of suggesting to the witness the evidence that should be given. For the particular circumstances of this case, the court decided that didn't happen here. Now, let's move forward. A case from the UK. There was a riot by inmates at an immigration detention facility. And as part of the resulting criminal trial, I imagine prosecuting the inmates, various guards took sessions with a third-party witness trainer in a witness familiarisation session. This training was one of the grounds of appeal against the conviction. So the guards were sent into groups of 8, so they were all conferenced together and given a, quote, hypothetical scenario. The hypothetical scenario involved prison guards involved in a riot at an immigration detention centre where they were guards. We say it's effectively the same set of facts. I probably didn't need to explain that. And the person running the session also conducted debriefing sessions with the groups of security guards to discuss their evidence. What say you, hot or not? Who says hot? Who says not? Oh, everybody in the room says not. Well, you're absolutely right. You're all very ethical practitioners. The training offered was wholly inappropriate and improper, particularly because of the similarity between the case and the evidence the witnesses were supposed to give. It comes far too close to coaching witnesses. However, it didn't undermine the safety of the conviction because the trial judge dealt with it felicitously by giving the jury a direction to afford the guards evidence little weight. So really, the only purpose that witness familiarisation session achieved was giving the defendant a solid appeal point and undermining their own witnesses. This is what happens when familiarisation is not done properly. All right, let's have a look at a fourth hypothetical. The witness underwent a professional witness familiarisation course. Most witnesses familiarised were using case studies prepared by an independent person and chosen by their solicitors, but 2 potential witnesses were allowed to choose or compile their own case studies. What happened here? Who says it was okay? Who says it was not okay? You've got very few facts to go on here. The judgment only deals with it in a light way. The judgment's about 400 pages long. But the case is called Ultra Frame and Fielding from the UK. The judge was critical of those witnesses who were allowed to compile their own evidence, but because it raised the risk of inadvertent coaching if the scenarios were too close. But for the other witnesses, the scenarios were sufficiently different to prevent any problems. Now, from my reading of this case, this was just one of the about 1 billion issues that were allegations that were an issue between the parties. This case ran for 92 days, and it involved allegations of industrial espionage, theft, arson, all sorts of things. I think the parties just hated each other and were throwing as many sticks as they could at each other. So this was just thrown up. The judge dealt with it very quickly because really it wasn't too much of a big deal in his opinion. A fifth one, a murder trial. I'll just check how we're going for time here. One of the prosecution witnesses that had attended a witness familiarisation course, and one of the grounds of appeal was that the evidence of this witness was inadmissible. The course was delivered by a member of the bar who was well aware of their ethical obligations, and the witness on the course was told of the possible consequences of collusion and was forbidden from discussing them. The witness underwent the process of familiarisation with the pitfalls of giving evidence and was instructed how best to deal with cross-examination. What happened here? Okay? Not okay? Probably okay, this one. Yeah. This is the case, the Crown against Salisbury, and the judge said this was an exercise any witness would be entitled to enjoy were it available. What was taking place was no more than the preparation for the exercise of giving evidence. No one engaged in special pleading with a view to gaining any expertise beyond the application of sound common sense. The witness received knowledge of the process and it assisted them to give a sequential and coherent account. They didn't obtain any unfair advantage because of this. And this is the quote to take home. There is, in my view, a difference of substance between the process of the familiarisation with the task of giving evidence coherently and the orchestration of evidence to be given. The second is objectionable, the first is not. How are we going for time? I might just quickly, I won't do this one as a hypothetical, I'll just give a quick rundown. HKSAR and Si Tat Fung, case from Hong Kong, slightly unusual. This was, as far as I can understand it, a case where the prosecuting authority was effectively the equivalent of the ACCC that we have over here. One of the witnesses visited the ACCC equivalence office over there 15 times for more than 23 hours of memory and refreshing exercises. And the last visit took place the day before trial. The judge at first instance concluded that memory refreshing exercises went beyond what was permitted. Probably fair enough. 23 hours does seem a little bit excessive. But he took this into account when giving weight to the witness's evidence. It was appealed, and on appeal, the court considered the judge had appropriately dealt with that issue. So this is another example of where overtraining your witness to give the best evidence they can actually hurts their case. You've got to be very careful. Repetitive drilling of a witness to a degree where his true recollection of events is supplanted by another version, suggested to him, is something to watch out for. So let's get down to the reason that I'm here, and hopefully you're all here. What is witness familiarisation? Well, it is not proofing or witness preparation by the witness's legal team. Witness familiarisation is an adjunct to this. It's not coaching. It's provided independently by people who have no knowledge of the litigation that the witness is involved in. That avoids any allegations of coaching. So it would be very difficult for the other side to impugn that the witness had been coached. It's a form of training for witnesses. It complies with all the guidance in the cases, all the guidance in the relevant rules. It is relatively new in Australia, but has anybody here practiced in the UK? No. I was talking to Jock down in your Sydney office on the phone. He said when he was working in the UK and he had to take a witness to a witness familiarisation session, he raised with the partner whether it was ethical, and the partner said, mate, this is done all the time over here. It's just par for the course in litigation. It's best practice in England and Wales, as I think it probably should be, and also in the US, although anybody who's seen a John Grisham movie might get the feeling that they probably go a bit further in witness familiarisation over there than we go over here in Australia than the courts would consider acceptable. Apparently they have PR consultants, acting coaches, the partners from the law firm, all there in the room to really groom the witness. I would be very hesitant to assemble that sort of arsenal of people. I just think that would overstep the mark. So what's the process that we run here at Loquitur? Well, it's typically a one-day course. The morning session, we run the witness through, depending on their level of familiarity with courtrooms, the court and the trial process. As I'm sure you all know, most witnesses expect it's like what you see on TV. You rush in on a $54 million complicated case and everything's decided by morning tea after everybody shouted at each other. Of course, that doesn't happen. Talk to the witness about what is actually going to happen, who's who, where to sit, how to behave, the role of the witness in giving evidence. We talk to them about cross-examination techniques, because there are techniques that we use, and we talk to them about strategies to deliver evidence effectively. Now, not all witnesses will obviously need to be told about this sort of stuff. One of the best witnesses I've ever seen in my life was one of my witnesses, thank God, back in November of last year, and he gave evidence in a very quiet, introverted, binary way. He was asked a yes-no question and he just answered yes or no. He was a very shy, introverted, quiet, binary guy, and he really did himself some favours. The people I find who have more difficulty with giving clear evidence are people who have built up companies, who are a bit of the bam, bam, boom, check out what I've done, you know what I mean? And they're super confident, and they need to be that sort of personality to run companies and have people get behind them and give them money and all that sort of stuff. These sort of people, in my experience, give terrible evidence because they get argumentative, they stick to their story, they won't compromise, they believe they're smarter than everybody in the room. They're generally not, and they trip themselves up. And so those are the sort of people who will probably benefit most from witness familiarisation, in my experience. Might be a bit hard to convince them they need it, but hopefully that's your job as lawyers. The afternoon session will involve a mock cross-examination session. Isn't that right, Clear? Yes. It'll be videoed for the witness, it'll be reviewed and analysed, and then we'll run through what the witness did well, what the witness could have improved on, and then we'll have another go, possibly with a different scenario. Now, I know what you're thinking. Is it ethical, Steve? Well, I think the way that Loquitur does it is ethical. Because it's conducted by third parties who have no knowledge of any of the litigation, we can't give any legal advice to the client about their case. We can't tell them what evidence to give. It's conducted using independent materials, so the scenarios are entirely made up. We wouldn't let witnesses make up their own scenarios for the reason we've seen in the Ultraframe case, and the material is generally chosen by us. The instructor is an independent barrister, so we're governed by the ethical rules of conduct as well. and it avoids the risk of the in-house legal team doing it. It's protection for solicitors as much as for their clients. The worst thing at trial is having to show up with your own representation, own separate representation as the client's solicitor because your own conduct is being impugned. Very embarrassing and expensive. Generally conducted it's conducted individually to avoid witnesses talking about their evidence and how they went. So it avoids that problem that we saw in Momadou. And it's generally the legal team or other third parties are not allowed to attend, so that, again, it creates that silo effect between the witness themselves and the client. You're frowning there. You don't like that idea? Yeah. What happens? That's a very good question. We'll come to that in just a second. Yeah, so it can be done for lay witnesses, of course, and experts. As a lot of you know, I'm sure, some expert witnesses, that's their job, giving expert evidence in cross-examination. So the better they are at that, obviously, the more likely they are to get another gig. And it can be done for all sorts of proceedings because generally the principles are the same. Although we probably wouldn't do it for child witnesses. I would have thought we've never been asked, but I think that's far too ethically fraught. But never say never. Right. So what are the benefits? Improved quality of evidence before the court. The witness will be calmer going into the box. Do you remember your job interview here at King Wood Mallesons? Were you nervous when you stepped in? Did you walk out thinking, oh, I shouldn't have said that, or oh, I should have said that? It's exactly the same for a witness giving evidence in the box. Stress and anxiety cause us to do all sorts of silly things. It promotes openness of justice and demystifies the trial process. I don't see that there is anything wrong with lay people knowing exactly what goes on inside the otherwise black box of a courtroom. It preserves the lawyer-client relationship during the process and hopefully will result in a time saving in the lead up to trial because your client will be more calmer. They won't be sending you emails at 3:30 in the morning from their phone going, but what about this? What if they ask me about that? So makes life easier for everybody. And here's, what was your name, sorry? Rebecca. To answer Rebecca's question, some questions. Does the fact, actually I'll deal with your question. You were asking about privilege. He should definitely answer. He should definitely say, yes, I have undertaken a witness familiarisation process. And the response to that is obviously that his credit will be impugned, but if it's done properly, I can't see there's any problem with it. It's not like he'll have to say exactly what happened in the witness familiarisation process, and if it involved him being run through a random scenario that there's no relationship to the litigation, can't see any problem. The materials
Stephen,
yes?
Jock here, just hoping you could repeat the question for us, please.
Sorry,
we can't hear Rebecca, who doesn't have a microphone.
No, that's all right, Jock, sorry.
Many thanks.
Rebecca is actively waving down the microphone. Sorry, I forgot that I'm talking across Australia here. I'd make a terrible news reporter. The question from Rebecca was, what do you do if your witness is asked in cross-examination whether or not they've undertaken a witness familiarisation course or have had some practice in giving evidence? And my response was they should definitely answer that they have. They should answer the question truthfully. The materials in the witness familiarisation course would probably be disclosable if the other side called for them. There's not much you could do about that. But on the other hand, if the witness has been run through an independent scenario and the people who did it had no knowledge of what the litigation was about, I can't see any problem with that. And I can't see why a judge would have any problem with that either. I can't see that it's any different to what lawyers do, at least at a high level, of running witnesses through their own evidence. In fact, it's probably safer than that. So I don't think there's anything to be feared by answering the question. Do we need to voluntarily disclose it? No, you don't. Criminal matters, it's a bit different. Now, I'm not a criminal lawyer, so I don't know the answer to this. In the UK, the answer is yes. In Australia, I don't know. Probably not, but if that question is asked, that's a question for someone at the criminal bar. Now, as I've said there, all documents, including any recordings, would probably be disclosable, something, or discoverable, if you want to use that word, probably something to bear in mind, and they wouldn't be subject to privilege because it's not legal advice. And because Loquitur doesn't give legal advice. Now, this is a big question. Are the costs recoverable? I can't see any reason why they wouldn't be. It wouldn't just be a normal disbursement in the preparation for trial. If this was being conducted by a party's own lawyers for a day, that would just be wrapped up in the cost of the proceeding. If it's done by an independent party, it'd just be a disbursement. Now, I'm not a cost assessor, but I can't see any reason why it wouldn't be. To round out the process, witness familiarisation, the purpose of it, this is the quote from Lord Justice Judge, witnesses should not be disadvantaged by ignorance of the process, nor when they come to give evidence taken by surprise at the way it works. None of this, however, involves discussions about proposed or intended evidence. Sensible preparation for the experience of giving evidence which assists the witness to give his or her best at the forthcoming trial is permissible. Such experience can also be provided by out-of-court familiarisation techniques. The process may improve the manner in which the witness gives evidence by, for example, reducing the nervous tension that arises from inexperience of the process. But the witness's evidence remains their uncontaminated evidence. So, a ringing endorsement of witness familiarisation there from no less than Lord Justice Judge. I can't do any better than that. Now, let's have a quick chat about Loquitur, what we do. We are Australia's leading witness familiarisation training organisation. We deal with the East Coast at the moment, but we're looking to expand across Australia as we get going. And of course, we can do anything by video link, but it's always better to see the whites of their eyes, as the barristers say. Cost of the course is $3,895 plus GST per day. Any questions? Check out the website or email the address or give that number a call. Any questions arising out of what I've just spoken about? No? All right. Clear. You're almost up. So Clea Denham here in the Brisbane office has very kindly offered to be a witness for, or to be subjected to cross-examination. Clea, which witness have you chosen? There were two. There's Sam Stone or John Jones. Sorry, Sam Smith. Sam Stone's the English singer, isn't he? Which one would you like to do? Joe Jones. Joe Jones. All right. Now, for those of you who haven't had the opportunity to read the scenario, I'm just going to get the affidavits. It's largely this. It's a contract dispute. So Smith & Co. are an events organising company. They engaged Jones Fine Foods to provide catering at an event. The event went very badly. The food was terrible by all accounts, or by at least Smith & Co.'s accounts. And so Smith & Co. are suing Jones Fine Foods for breach of contract and, one would imagine, misleading or deceptive conduct because of the quality of the food they provided. So Mr. Jones is the director of Jones Fine Foods, and I am going to pretend I'm the barrister for Smith & Co. Now, what are the issues that we might be thinking about here? What always happens in contract cases? How was the contract formed? What were its terms? What were agreed? Misleading or deceptive conduct? Who said what to whom? All those sort of things. Now, a bit more background. According to Mr. Smith, he came across Jones & Co. at a networking event where Jones Fine Foods marketing manager was there, said they'd do great. He engaged them to provide catering for this event. In November, the event finally came around, and then it was actually at the event that things went pear-shaped. All right, you ready, Clea? Okay, now let's make sure that you can get in in shot. Am I in shot there? All right. I might just turn this around so I can lean on the bar table like I would if I was actually in court. Can everybody still hear me across the wide brown band?
We can.
Excellent. All right. So, Mr. Jones, you've prepared an affidavit. I'll just check the time before you go. You prepared an affidavit in this proceeding, haven't you?
Yes.
And is everything in that affidavit true and correct?
Yes.
So you don't want to change anything?
No.
You said that your company, Jones Fine Foods, it's run a restaurant, or runs a restaurant, doesn't it?
That's right.
And a delicatessen, is that right?
Yes.
But it's developing a catering business.
That's right.
So it's relatively new business for you, isn't it?
It's the third limb to our business, so it's the most recent.
Mm. And the reason you engaged Mr. Aaron Sellens, your marketing manager, to attend this networking event was to promote the business. Is that right?
That's one of the reasons, yes.
And back in May, it was a very new business. It hadn't actually done any catering at that stage, had it?
I believe we've done about 10 events.
10 events?
Yes.
And those events, though, when did you do the first one?
I'm sorry, I believe I dealt with that in my affidavit.
You didn't?
I didn't. Prior to the event in November, we had done 10 events.
So have you done 10 events between May and November? Is that what you're saying?
Yes.
Well, you just said that you'd done 10 events before May. So which is it? Is it May or November or before May?
Between May and November.
Right. So at that time that Mr. Aaron Sellens went to the event, or went to the networking event, Jones Fine Foods hadn't done any catering events whatsoever, had it?
No.
Right. Now, the restaurant, you say, is 5 stars.
Yes.
5 stars according to whom?
If I'm able to refer to my affidavit.
Of course.
Thank you.
I can tell you it doesn't say.
No. It's one of the institutions in the local dining scene, but I'm not sure where the 5-star came from.
That's the sort of thing I would remember if I was a restaurant owner. And I suggest to you it's the same thing with you, isn't it? If somebody gave you a 5-star review, you'd remember who they were, wouldn't you?
Yes.
And you'd remember what they said in the review?
Yes.
But you can't remember. Right. Now, you've said that Rachel Reeves was working for you.
She's in our administration team.
And she's the one who you say took the call to book this event, is that right?
Yes.
And you haven't got an affidavit, or you're not calling Ms. Reeves as a witness, are you?
I'm not sure, sorry.
You're not sure, but this is your case. You understand that, don't you?
Yes.
Yeah, but you don't know who you're calling as a witness and who you're not.
No, I'm just a witness.
Right. It's your company, though.
Okay.
Yes. And do you have any record of what the plaintiff, my client, ordered from you for this catering event?
I believe we have a quote and an order form.
And where do I see that?
It's not one of the exhibits.
No. So that hasn't made its way into your evidence either, has it?
No.
I suggest to you that my client ordered and specified that there should be Wagyu beef on the menu. Do you agree with that?
I'm aware that Mr. Smith said he was interested and had enjoyed our Wagyu beef at our restaurant before, and that Ms. Reeves had indicated that she would do what she could to get it on the menu. But as we're a fine dining company, we have a seasonal menu, and that's why there's a guarantee on the order form that we don't agree as to what will be served on the day, and for that reason, or that is one of the reasons why the Wagyu beef wasn't on the menu.
Do cows migrate though, Mr. Jones?
No.
No, they're generally contained on farms, aren't they?
Yes.
And slaughtering of cows happens year round, doesn't it?
Yes, I believe so.
So Wagyu is not a seasonal ingredient, is it?
Yes.
Are you saying yes, it is a
Sorry,
seasonal ingredient?
No, it's not a seasonal ingredient.
All right, very good. I might stop there. Round of applause all over Australia for Clear Denim. All right, I'll just make sure I'm in shot. What I might do is quickly run through what I was doing with Clear there. Can everybody see me? Yes, great. And give you a bit of a rundown of the techniques. So quick thing that barristers do, we're all taught this in bar prac course and all the books. It's an Australian expression. It's called closing the gate. And it comes from, who here has gone to the Echo or the Royal Easter Showdown in Sydney? What do all the kids like to see? The sheepdog trials. What does the sheepdog do? The sheepdog slowly herds the sheep into the pen, and then the really good sheepdog takes the gate with his nose and he closes the gate behind him. So in that circumstance, the witness is the sheep and your questions are the sheepdog. So you ask the witness a series of questions that actually gets them into a proposition that they can't disagree with, and then you close the gate behind them. So what we're talking about with you, Wagyu beef not being a seasonal ingredient. You couldn't say, well, I don't know, because that would expose you as being a really dumb restaurant owner. So you had to say yes to that. So you had to agree that Wagyu beef wasn't a seasonal ingredient. Just a little example there. Some people prepare cross-examination down to a fine detail. Some people just like to just go with the flow, see what happens. In my experience, the best way to do it is to have a mixture of both. You need to know what points you need to hit, but you also don't want to miss anything that's given out as gold. So a little piece that Clea gave me there was she got confused between when the catering events occurred, whether they occurred beforehand or after the networking event. Naturally, as a barrister, I would be saying, Your Honour, this witness's evidence can't be believed. They can't even remember when these catering events were. Catering is central to the business of the company. They can't even get their own stories straight. If there's any conflict, if there's any choice of credit between witnesses, you should choose the other person, something like that. So they're just a few little examples of what we do as barristers, and a few examples, I guess. It's pretty easy for me because Clea's not familiar with the situation and has only read the affidavit, what, this morning? Yeah, right. So it's shooting fish in a barrel. But in real life, people still get nervous and they change their story. So that's a good example of just trying to get people to calm down, possibly know what techniques are being used against them and know how to deal with them. So that is pretty much the end of the story. Thank you all for coming. As far as I'm concerned, you all have one ethics point. Hooray! I hope I've elucidated the process of witness familiarisation, what Loquitur does, and how the process can generally be done safely without exposing you or your client to any legal risk, the benefits of it. And unless there's any questions, I'd like to thank you all for coming. I hope you enjoy your sandwiches. Any questions before we go? All right. Well, thank you all. And thank you all.
Many thanks, Stephen. On behalf of everyone who's dialed in by WebEx, we really appreciated your time and expertise and experience on that. And also thanks to Clea. I think we're all going to look at menus slightly differently now if we know where it could land us. So many thanks.